you can maybe wait a little bit. But I'd say, a year to 6 months, it's a good time and you're set on a name or a variety of names because the one you want may be taken. I think that's a good time. I think I love clients who come, look, I love all my clients, but I'm especially impressed by the clients who come to me who are saying, I think I have a name that I'd like to investigate if it's available because I'm planning to, launch my product in 6 months or my service in 6 months. I mean, that's where you want to be.
So in terms of trademarking names.
Sure, we can start there. Yeah.
Would you say, okay, is it the name of the bit? I know you can do like the logo, all these different aspects. Would you do the name of the business or like the name of, let's say, a course, or maybe both? Maybe we're suggesting both, right?
I'll give you the legal answer, which is super frustrating. It depends.
Okay.
So one thing to not get confused about, which is, we all still trip up on it. The business name isn't always the brand name. Mm-hmm. So for instance, I'm trying to think of, I can't think of one off the top of my head, but let's say BizCorp, owns IBM. I mean, IBM obviously, but let's say that, they don't care about BizCorp. They don't care what's on the certificate with Delaware or they're New York where they filed their corporation. Mm-hmm. That's their corporate business name. That's the LLC or the Inc. that goes after it.
Yeah.
The brand would be IBM or Nike or Amazon, or, they don't have to be the same.
Okay.
Often they're not. So, no reason to feel restricted about, oh, well, I created a company and I called it this. I now need to trade. Is that what I have to trademark? You can trademark whatever you want as long as it fits in the parameters of the trademark office. So then that goes into a whole other topic of what name to pick if you're going to go on name angle. And that could be, you get a whole day for that, but I'm happy to get into it if you like. You point me in whatever direction. But that, I think that answers your question about the business. What do I trademark? Oh, and in terms of the course or the name or both, look, you're never going to be, as long as you use the mark as you've applied and gotten it registered, you can keep it forever, theoretically, as long as you pay some maintenance fees and keep using it. Mm-hmm. But I wouldn't say to go out and trademark everything if you don't think you're going to use it all, because that's expensive. And then you're going to lose them. You'll lose them. It's a use it or lose it game. So let's say you got a brand and you're already in business, okay? And you're like, ooh, shoot, I need to make sure I'm not stepping on anybody's toes. So you'd search and clear the name you're already using. And if you had a course that you want to independently market, so it would be like, I keep going back to Nike. It's just the easiest one, but it's like Nike has the Air Force sneaker, right? So they probably have a trademark over the Air Force sneaker. But, in the beginning, I don't know if you need to trademark each course. We don't need to spend a ton of dough. There's other things that can protect you in terms of, pieces of your business, often through contract, of being ripped off. But you want to start with the thing that if you were like hanging a banner somewhere, or if you had you're hanging a shingle, what would be on that shingle? That's what you want to start with.
Okay.
The other stuff you can investigate with your attorney on a case-by-case basis. Hey, how aggressively am I going to market this outside of my already existing marketing? I think would be
okay. That makes sense.
The way to, I think like Apple, the iPod, right? I mean that, duh, like they definitely trademarked that, but until it's just very case by case, but we don't have to do that all at once.
Okay. So let's talk a little bit about registration then.
Yeah.
Is that different? Or is it kind of under the same process?
So mostly what I've been talking about is registration.
Okay. So the
registration but there is a reason for confusion, because the United States is what we call a first to use country. Mm-hmm. Some countries are first to register. It's kind of like real estate or like title of a house or something, right? Mm-hmm. So in the United States, we value those who are, ironically, even though I gave this speech before, we value people that are using products and land, really, you know, but in this case, marks. So therefore, if you're someone who's never used a mark, but you want to, and you don't do a search, you just go and you file it. And then you get a cease and desist letter from someone saying, I've been using this mark for 10 years. And then you say, well, I registered it. If they've been using it, they have rights. They don't have as much rights had they registered it before, but they still have superior rights to you. So this is where it gets confusing, because it's like, well, what do you told me? You just told me to go register it, but now I could have not read. The benefits of registration is you get a lot of power in court if you have to sue.
Okay.
And you can get a lot more money back. We call them damages. You can get a lot more money damages if you have to sue. But on the flip side, if someone who doesn't have a registered mark but has a mark, we call a common law mark holder. They could gum up the works for you if you don't do that initial search to make sure they're not out there either. So registration is what I advise. Okay. Because it gives you the most power to protect your mark. If you don't register it, you're kind of at the whim of each state's rule, each state's laws, and you just don't have those powerful laws that the United States government gives a registered holder. It's a long-winded answer. I hope that helps. But, you know, it's when I'm talking about mostly it's registration. Yeah.
Can you be using a trademark that's not registered?
Yeah, it's just not recommended.
Okay. All right.
So, yeah, look, I mean, chief justices have written novels on this stuff, right? Yes. But it's sort of, look, I mean, I guess an easy way to think about it is just driving without insurance.
Okay.
You can do it. You won't get arrested, but I hope you don't get a fender bender. Yeah. Right. Yeah. I think that's the easiest way to think about it.
Okay. So what about trademark infringement? Do you have any comments that you'd like to share on that topic?
Yes. God willing, this is the only way anyone ever has to talk about in the audience, because trademark infringement is basically what happens when you're using somebody else's mark or they're using yours without permission.
Yeah.
Okay. And that's where registration really comes into play, because if you have a registration that's proper, you did all the search and everything, and you're good to go, you can really knock that other fella or gal out of the picture. You can get what we call an injunction, which is a court order to stop. You can get your attorney fees back, assuming they have any money to pay them. You can get money damages. So it's very powerful. It's a very powerful weapon to have if you run into this issue. If you don't have any of that, which is kind of what I talked about before, you don't have as much recourse. But infringement is the big bad, hey, you're stepping on my toes in the same or very similar marketplace. So just one thing I want people to understand is like, hey, I want to trademark the name Squeegee, right? Or make it easier, Squibby. And I sell tires. But I saw that person who sells gum also has Squibby. And I would say, I'd look into the facts, but I would say, don't worry about it, because those are two separate classes of industry.
Right.
So I think the takeaway here in this like long legal treatise I've ended up giving is that it's all about, we don't want the consumer to, even though we're all the business owner here, so we don't want the consumer to be confused. So we think of it as when grandma goes to the grocery store and she's looking for her favorite brand, Coca-Cola. And then she gets into the aisle and she sees Coca-Cola and Coca-Cola and Kula, and it all looks or like something totally different, but it's in the same packaging with the red and the cursive. She's confused. She's standing there. She says, what am I going to buy? And then for Coca-Cola's issue is, what if she buys Coca-Cola thinking it's Coca-Cola, takes a swig and it's disgusting, and she says, I'm never buying Coca-Cola again, and I'm telling all my friends never to buy Coca-Cola again, and there goes your goodwill hit. So it's all, at the end of the day, it all comes back to what we call consumer confusion, the likelihood of consumer confusion, and that's what we're always the touchstone. We just want to avoid that as much as possible.
Okay. All right. So can we try to boil this down into some action steps?
Beats me. I don't know, you tell me. I don't know. Yeah, we'll try.
What would you like, just for our audience who's listening, thinking, gosh, so what do I do first?
Quivering with fear now. Okay. So yeah, none of this is meant to be super scary stuff. I think it depends where you are in your business.
Okay.
Let's do the more common scenario where you're already cooking. You've been in practice for 3 years. You've got a name that people start to know you by. It's not necessarily your own name. It's a name you came up with. You're feeling really good. No one's come out of the woodwork saying, hey, that's mine.
Right.
I think the next step would be in that scenario, assuming you want to take the step to protect your brand name, which I think is wise. You consult with an attorney who would conduct what we call a clearance search. And what that does is you scan the landscape. Usually attorneys use software to do that. It's a whole cottage industry to determine if there are other people or businesses that are using the same or similar mark as you, because it's all about similarity, right? So I think that's a really good step, because if you find out that there are a lot of folks out there, you're going to have to reevaluate. So I'll give a good example. This is kind of similar to this. I don't know, there's people from all over the states, but on the East Coast, there's a deli brand called Lenny's Delicatessen.
Okay.
And it has going to Lenny's. We're going to Lenny's. It's a huge chain in the East Coast. And then somebody in the southern, still on the East Coast, but in the southern states, had like a Lenny's, like a Leonard's deli sandwich shop or something. And they sued him. And Lenny's, which is a big bad company, had to change the name, and you saw them like taking down placards and stuff. So it can really dent your brand identity, and rebrand. As you all know, rebranding is expensive. So that's why I think being aware of the dangers is good. And then you can make a cost benefit analysis to whether to rebrand or to start over, all that stuff. If you haven't started yet, I think it's close to a no-brainer to consult with an attorney and do a clearance search, and see what's out there, with being open to a variety of names. Because now you haven't wed yourself like the first example, where you've already sunk all this money into advertising and labeling and packaging. You got to be open, and that's why I titled it "What's in a Name," because we get very, very wed to these and excited about a name we picked, but there's a lot of, not only may it already be taken, but the United States Patent and Trademark Office, USPTO for short, may say, you know what, that name, as cute as it is, it doesn't meet our standards of what is trademarkable. And there's a whole other stuff we can talk about there. But what the Trademark Office does is they look in their own database and they say, well, somebody already has something too similar in a similar field, or this is too what we call descriptive of the goods, meaning like, I sell crunchy cupcakes. It's like, no, it's just a crunchy. You can't do that. It gives you too much of it. Right. Yeah. So you'd be surprised, but I get those a lot. But so you got a lot of hurdles that you got to navigate with it. I think with an attorney, because it's very difficult without having someone with a bit of a background in this, even though you can do it on your own, but it's as I think, as we can all tell from this, only half an hour, it's complicated stuff.
It is.
When you get to the granular level of it.